Welcome to this webinar in a series on helping you navigate the resources and various options available to you as an operator, primarily focusing on recent legislation. This webinar will focus on providing updates and answering questions related to the Families First Coronavirus Response Act. This webinar is brought to you by Performance Food Group to provide you with ideas and resources to help you in this time of industry distress. All webinars and other resources can be found on Performance Food Group's website under COVID-19 Resources for Operators. Next. Page 2 contains certain disclaimers. Please review. In addition to the legal disclaimer provided, as you're aware, we're in a very fluid and ever-changing environment. As regulations and implementation guidance is finalized, certain information presented today may change or be further clarified in the future. Next. Today we will focus on providing updates and answers to questions related to the Family First Act and the related legislation. Next. My name is Keith Middleton. I'm the co-managing partner of Fahrenheit, overseeing our consulting and fractional management services. Fahrenheit is an advisory and search firm primarily serving middle market companies focused on business strategy, finance and accounting, and human capital. Joining me today is Nathan Dewey. He is a managing director in our human capital practice, serving as an HR consultant to middle market companies. Nathan served as a human resources leader in the food service industry for over 17 years and will be sharing the updates to the Family First Act today. Next. So Nathan, the first thing maybe just to ground people, there's been a lot of legislation that's been enacted in the last month or even less. Can you provide a little insight onto what companies should be aware of and where to turn to?
Okay. First of all, the Family First Coronavirus Response Act was passed and became effective on April 1st of this year. It contains two important components that employers need to be aware of. The first one is the Emergency Paid Sick Leave Act, which provides 2 weeks of paid time for employees under certain circumstances, and an additional Emergency Family Medical Leave Act, which is an expansion of the existing Family Medical Leave Act and provides additional 10 weeks of paid leave under certain circumstances. So those are the two main components, and the questions that we'll delve into later primarily deal with these two aspects of the Act.
And as you will see, the main place that employers should go to is under the Department of Labor website, specifically the Wage and Hour Division. And we've included that link here as well as on Performance Food Group's resource page. That has everything you need to know, Q&A, and it's continually updated as they issue more guidance. Next. With respect to the Family First Coronavirus Response Act, there's been a lot of additional guidance issued and continues to be issued every day. Today we will discuss two specific areas, enforcement and leave guidelines. In the first area on enforcement, the DOL continues to issue new and clarifying guidance on various aspects of implementing and administrating the paid leave provisions under the Act. While things are becoming clearer and new guidance provides valuable insight into what the DOL is thinking and how they will enforce the requirements on employers, I guess the question for you, Nathan, is what does the DOL mean by enforcement? And can you give some details into what those areas are, what they could be, and what all of this means?
Right. Okay. Well, you know, I think the first thing we need to keep in mind is that, you know, it's important to understand that when federal laws are enacted, especially laws of this scale, it's a fairly big, fairly comprehensive law that involves a lot of mandates for employers. under those circumstances, generally speaking, the federal law will give you about 6 months to get ready to comply. Because of the urgency of the coronavirus pandemic, the Department of Labor moved pretty quickly on this one, and considering the speed of the enactment of the act, I think the DOL was thinking realistically about the challenges that employers are going to face getting up to speed and understanding the law and implementing it and providing the leave that is required. So primarily, the first thing, under the guidance that they initially gave, they suggested that it would take them at least 30 days, a kind of a grace period, so to speak, to give employers time to settle in, to understand the law, and to start getting requests. New guidance has since come out, and effective today, actually, April 17th, they will be actively enforcing the law, retroactive back to April 1st. And they have tasked their wage and hour division to handle complaints and to work on enforcement. Now, recently, I think that what you're going to see as far as enforcement is concerned, it's going to be like many things with employment law, and that is the audits and the things, the investigations that come generally spur from employee complaints. When they hear problems and concerns from employees, that's where things generally stir from. So I think what the DOL is doing right now is they're trying to, again, do their balancing act a little bit, and they're giving employees a website for them to go to and some directions to go to if they feel like they have been denied access to the leave that the Act provides, or if they feel like their employer has kind of subjected them to not being able to do leave because they've basically taken the waiver and basically said that we're not subject to the law. So they can question those two things as part of the Act. And they've been given a website to attend, and they've been encouraged by the Department of Labor to visit their local wage and hour office if they feel like they've been denied their rights. So they're going to start from there, and based on how much activity they get from employees, I guess we'll see and learn a little bit more about how aggressively they're going to enforce the law. I still maintain that they're going to kind of take an easy hand with this a little bit, understanding that how quickly the law was put into place. And I think if employers are found to be in violation, I think they can basically see that the Department of Labor is simply going to ask them to provide the leave, make the employee whole, and I don't think you'll see a lot of penalties, especially in the early stage.
Great. Next. So the second part, where there is a lot of guidance coming out, relates to all the different new laws and guidelines and regulations around leave. And we have a few questions that we'll go through with some very specific guidance that came out from the DOL. And the first one is, can an employee claim leave benefits under the Act while on workers' compensation?
Well, the answer to that is pretty clear. If the employee is disabled, if the employee is off of work on workers' comp and they're not able to work in any capacity, they're totally disabled, then the Act says that they're not qualified for either the emergency family medical leave or the emergency paid sick leave. Now, if the employee should return to the employer in some capacity, some light duty capacity, then it's likely, if they become unable to work or unable to telework, that they would then become eligible for the benefits. But while they're on disability because of a total disability, they would not qualify.
All right, the next one is, can an employee qualify for leave to take care of a child other than their own child or children?
Okay. Well, since we have two types of leave here, the answer is different for both. The first one, if you look at the Emergency Family Medical Leave Act, the one permissible reason you can take in order to take this leave is to care for your own child. So under that provision, an employee taking care of another child, not their natural child, would not be a reason they could claim any paid time off under the Emergency Family Medical Leave Act. Now, under the emergency paid sick leave portion, which is 2 weeks again, they could, in fact, be eligible depending on their relationship to the child. If the child's place of school is closed or their child care is closed for COVID-19 reasons, or the employee is subject to quarantine or self-isolation either by the federal or state agencies or by a medical professional, then the individual employee could take leave to care for that child. But the underlying factor here is they would have to prove that they are a caregiver for that child, a primary caregiver. So they can take it potentially under the paid sick leave. It would not be eligible under the Emergency Family Medical Leave Act.
Great. Can both parents take leave and get the benefit simultaneously to take care for the same child or children?
That's always an interesting question because a lot of companies, and there are some companies out there who employ, especially small companies, have a tendency to do this more than most. They have a tendency to employ both parents. And when you have a situation like that, the employer is trying to do a balancing act there as well. And the guidance from the Department of Labor has been a little confusing. So what I'm going to do is kind of go off the beaten path here a little bit and read to you what the Department of Labor says about that particular question. It says you may take paid sick leave or extended family medical leave to care for your child only when you need to, which I found an interesting comment, and actually are caring for your child if you are unable to work or telework as a result of providing such care. Generally, you do not need to take leave if a co-parent or co-guardian or your usual child care provider is available to provide the care your child needs. So basically what they're saying is if there's an alternative to you taking time off, you're not allowed to take time off. Now, I think personally, if you are an employer and you have both parents working, I think this is the time for you to consider potentially doing the intermittent part of the family medical leave that would allow you to kind of split up the responsibility between the two parents, where you can retain one at work and one can stay home with the child. I think that is something that I think most employers should take a look at and try to work out kind of a schedule with the two parents to where they can always provide for their child, but the other parent can be at work. So it's a time for them to get a little creative with the intermittent leave provision and try to work it out to where, again, they're balancing their need with the need of their employees. Okay?
What constitutes a child care provider?
Well, and that one, I mean, if you're like me, you had family taking care of your child from most of their preschool aged. What the Department of Labor basically says is that anybody who takes care of your child, whether they're paid or unpaid, whether they're professional licensed or they're just the child's uncle, aunts, or grandparents, are considered child care providers. So it's a very, very broad definition. It doesn't matter if it's a neighbor or a friend, a relative, or a professional service that takes care of your child. All of those particular types of care providers are included.
Okay. You know, one of the things that relates to the leave and children being at home relates to school closings, and there's been some clarification around how that's being defined under the Act. So what got defined?
Well, it's interesting because many employers have kind of seized on this and said that if, you know, since many schools are doing kind of online training, online learning now, they got their students doing some schoolwork and some assignments online, that frees them up from that particular part of the Act. Unfortunately, the Department of Labor has come out and said that even if the child is getting some online learning as part of their schooling, and even if they have assignments that they have to complete and turn in, the Department of Labor still considers that school or place of care closed if the facility is physically closed. In other words, if the child cannot go to the actual facility because the facility is closed, then by definition, the school is considered closed. So the online learning provisions and some of the online attempts to keep learning happening during this period of time do not necessarily interfere with the employee's ability to use leave under those conditions.
Right. Okay. Can an employee self-quarantine without any medical intervention and still be qualified for the leave?
No, they cannot. I mean, the Act, again, I think this is one of those balancing things with employers, because I think employers were concerned that employees would be concerned about being exposed and take it upon themselves just to stay away from work, and would then draw the benefits of the time off, the paid time off benefits associated with the Act. But unfortunately, with the DOL has made it clear that individuals cannot isolate themselves because they're afraid of being exposed and still be eligible for the paid leave. Again, it's something that if an employee, again, as we've talked about before, has an underlying or some underlying medical conditions that makes their fear a little bit more real to them, then I still encourage employers to take the proper steps to understand the employee's concerns and work with them as best they can. But technically speaking, under the Act, if they self-quarantine or they decide themselves to stay away from the place of work, they would not qualify for any of the benefits.
Okay. And in the last one, in this one, even with our own firm, if companies have not, they should put out some type of a policy around employees, the various leaves, and what all the what-ifs are if an employee contracts COVID-19 or someone in their family or they've been exposed, around what is the company's position and what the company is going to do. And one of the ones that a lot of companies got caught up with is if an employee had COVID-19, what was the gate to allow them to come back to work, and specifically around providing medical support and sign-off. And so I know the DOL came out with some specific guidance around that. So if you could help what that was.
Yeah, again, their guidance in this area has, I guess, what you would call evolved over the last several weeks, because initially when they came out with their guidance, they were very concerned, I think, as most public officials were, that depending on the size of the infection of COVID-19, that medical facilities and doctors could be overrun with patients. So they were very concerned about that initially, and because of that, they basically said that you had no right to ask for any kind of guidance or any kind of documentation when an employee requested paid leave under the paid sick leave provision because of their own illness or because they've been diagnosed or they've been quarantined. You could not really ask for a great deal there. Over the last few weeks, they've kind of softened that in some areas and tightened it up in other areas. Now it is permissible and in some cases required that the employee, when they request leave because of their own illness and because they're either been diagnosed or they are their medical professional feels like they should self-quarantine because they've been exposed, they must at least provide the name of the physician and the location of the physician who issued the quarantine or the stay-at-home order to them. So that's about all you can get at that point. Now, when the employee wants to return to work, there I think the Department of Labor has seen the importance of making sure that when employees return, they return with a clean bill of health, because the employer, retains the responsibility to protect the rest of their workforce. And so they've lightened up and loosened up a lot of the requirements, and it is now allowed, in some cases required, that the employee provide a return to work release indicating that they're clear of the virus by the medical professional or the service that has treated them, and provide that to their employer before they can return to work. So it's a little light on the front end when they request it. On the back end, when they're returning to work, I think the Department of Labor understands the importance of making sure that the employer has some level of assurance that they've been healed, they've been treated and or healthy again before they put them back into the workforce. So that's kind of where that is right now. I do expect it to evolve a little bit more as they go in, and as more people, thankfully, are recovering from the virus and are returning to work, and as more companies begin to open up, I think you'll see a little bit additional guidance on that. So I would stay tuned.
Great. And as we've talked about internally, one of the things that employers need to start thinking about now is as employees start coming back to work, as the stay-at-home orders start to get released, what are they going to do at their workplace to have their employees comfortable about coming back to work? And that is something that we'll talk about in a future webinar.
Right. There's a lot of that coming out right now, Keith, and a lot of companies are really starting to give that some thought, because the reality of the possibility of reopening is becoming real to them, and they're starting to look at that at great length. And there are some considerations that they should make, and I think that's part of their decision process as they open up their facilities.
Great. Okay. Next. So as always, further information and details on today's subject and others, and several other industry and legislative related resources are links on PFG's website and on Fahrenheit's Insight page, where we post new information daily. You will receive a webinar survey. You can provide feedback and also ask additional questions. Thank you for your time today, and stay healthy.